Nous sommes en audience publique, Monsieur le Président.
The court officer, we are in public session, Your Honor.
Thank you very much. Witness, welcome to the courtroom, and thank you for joining us. Your oath will now be administered to you. Court officer, can you kindly administer the oath or the declaration?
I solemnly declare that I will speak the truth, the whole truth, and nothing but the truth.
Thank you very much. What you just declared is, in a nutshell, all that we require of you for your period of stay with us in this case. Just to speak the truth, the whole truth, and nothing but the truth. If you do that, you would have helped us a lot in our work. And doing that requires the simple matter of really listening closely to the questions the lawyers would ask you while you're in court. The prosecutor would begin asking you the questions, and after they're done, the defense lawyers for Mr. Ruto and possibly also Mr. Sang will have the right to ask you questions also. As they do that, just listen carefully, make sure you understand the questions they're asking, and after you've understood each question, then you do your best to answer it truthfully to the best of your ability. What we require of you, what we're more interested in, or most interested in, is what you witnessed yourself firsthand, what you saw yourself, what you heard, what you smelled. Essentially, firsthand experience from you is what we're interested in. Try not to guess at answers. Try not to draw inferences if you can avoid it. Inferences as in there's one fact and another fact, and then you come to your own mind that because there's one fact and a second fact, it necessarily means that a third fact also is the case. Try not to do that. It is the lawyers who will do that at the end of the day. Just concentrate on what you saw and experienced or heard. Try not to guess also. If you do not understand the question, tell them you do not understand the question. If you do not have an answer, tell them you do not have an answer, you don't know the answer to that question. That's all right too. Try not to guess if you can avoid it. There is another matter that's very practical, and that is the matter of we want to make sure that your trip here is worth it, so that what you are telling the court is actually heard correctly and recorded properly. That requires you to pay attention to the work of the interpreters up there and the court reporters. They will help to interpret what you say into different languages of the court, and also to record your answers for the transcript. You need to assist them in doing that work by speaking slowly, not too slowly, but don't speak too fast. Also speak in chunks of information and not to give continuous flow of information that may take up to 10 sentences continuously. Speak deliberately, stop, so that they can digest what you're saying and capture it properly and record it. There's something we call the gap rule. The gap rule also assists in making sure that your answer is captured correctly. That is a gap that must be observed between the speaker asking you the question, between when he finishes asking the question and when you start answering it. There's a little gap that needs to be observed. We call it the 5 seconds rule. It also helps interpreters and court reporters to do their work. If you observed all these things, you would have assisted us a lot in our work. And again, I thank you for coming to give us what you know.
Mr. welcome, Your Honor.
Thank you.
Your Honors, just before we do start, just a matter of procedure, there is a question of bundles that the prosecution had prepared for this witness, which contained the annexes of the statement of the witness's statements, and other prior statements as well. Before we started today's hearing, Defense Counsel Mr. Hooper indicated that he strongly objected to a lot of these documents being in the bundle that was going to be provided to the chamber. Obviously, the prosecution has no problem with removing the documents that are deemed problematic by Mr. Hooper, but obviously we'd like the chamber's guidance on this matter, because the fundamental reason why the prosecution inserted these documents is so that the chamber could possibly refer to them, ease of usage, during the examination or cross-examination of the witness. So I leave that obviously in the hands of the chamber. If need be, we have the bundles right here. We've recuperated them. We can either provide the chamber with an amended one with simply the annexes of the witness, or one with all the documents, depending on what the chamber requests.
The matter would be, the objection, Mr. Hooper, would be as to statement, you said?
Well, essentially what I objected to were documents which in the normal course of events would not be admissible in chief. And when I raised that with my friend, he said he'd put them in, I thought, over kindly, because they might be documents I'd want to refer to. But of course, if I want to refer to documents, I'll put them in my own bundle and provide that to the judges in due course. So I'd submit that this is the better and more appropriate position.
But the bundles are not evidence. They're just handy package of information that may be useful. They're not being admitted. I can assure you that in previous instances, I have not looked at witness statements before coming here. But in the course of the arguments or the witness testimony, when the questions are raised as to what they said, then we look at them at that time. That's how I've done it.
Well, I've raised no objection to the statement going in, because we learnt last week that that was the position, that John has access to them and refers to them. So I didn't object to that. I objected to other documents which, so far as I can see, would not be properly admissible in the course of an examination in chief of the witness, one's own witness. I thought it was quite inappropriate that those documents would be put in at this stage. If in the course of the trial those documents become relevant, they will, I would anticipate, become relevant only in cross-examination, in which case Your Honour will be provided with them. But I don't think this is an opportunity for the prosecution to pack its bundle with all manner of statements. And so I suggested there was a line to be drawn, and I hope that's an appropriate one. So the position is at the moment that what Your Honour has here is a bundle that contains the witness's statement to the prosecution, the fundamental statement, and it includes the exhibits, and it includes some other matters which, in the normal course of events, I do anticipate my friend seeks to introduce. May I say that in respect of certainly one of those items, there will be an objection in respect of its admissibility, but it's still in the bundle.
All right, we will, our prosecutor can hand out the bundles. What we'll do is Mr. Hooper has already flagged his concerns. At the appropriate time, if the prosecutor makes a move to tender any of these documents, we will hear the objections at that time.
Mr. President, on that issue, may I indicate that I didn't get access to the document?
You did not?
I had not been given. And so I reserve my right to object at that appropriate.
All right, definitely.
Thank you.
All right, why don't we
Your Honors, given the...
get going on this witness's testimony?
I can perhaps start immediately with the witness, but given the objections by Mr. Hooper, we had already removed some of the documents. I understand that we have approximately 55 minutes of testimony today, and most probably we'll only be getting to one of the documents. So for defense counsel, we will provide the full version after today's session. I understand that the chamber has. Are you saying
that we have the full version?
Yes, Your Honor. From what I understand, I'm looking at it right now, and I see that that is the full version. Yes.
All right.
I just want to make sure with Mr. Rojas whether these documents have tabs A and tabs F on them, in them still incorporated.
The tabs are still there, just not the contents.
Yeah.
There is nothing in tab A, and there is nothing in tab F of my own bundle.
What we can do, Your Honor, is we'll supplement and add those after today's hearing. That's not a problem.
Okay, please proceed.
I'd like to request that we go into a private session, Your Honor.
For how long?
For the first part, it should take 10 to 15 minutes, Your Honor.
All right, private session.
The court officer.